if you can hear me there at the star, we're not, you're frozen.
I can hear you.
Can you hear us?
I can see you and hear you.
All right, go ahead and redo the video now, maybe that'll clear it up. Your video was frozen on my screen before. Okay, there we go. That's good, great. All right, so this case number 21 CR 73, State of Ohio versus Larry James Smith, second, and you are Larry James Smith, second, occurring from Star, correct?
I am, yes.
All right. Now, Mr. Smith's attorney is Dennis Kirk. He is appearing by Zoom. This hearing being conducted by Zoom. And also appearing on behalf of the state is Assistant Prosecutor King. And Mr. Kirk, you can find a vote consenting to having this hearing conducted by Zoom remotely rather than having Mr. Smith have to travel out here to start.
Yes, Your Honor.
And you're agreeable to that, Mr. Smith? Hello, Mr. Smith?
Yes, I'm sorry.
Okay.
Yeah, I'm with you.
Okay, thank you. Now, Mr. Smith, since you are not in the courtroom next to your attorney, if you have any need to talk with him about anything during this hearing, just tell me, and I can put you and him into what's called a breakout room, where it'll be just the two of you on the screen talking to each other. No one else will be able to hear you, and it won't record your conversation, okay?
Okay.
All right. Now, Mr. Smith is charged with possession of cocaine and aggravated possession of methamphetamine, both 53 felonies. This is the final pre-trial, and the trial is set for August 12th. Now, I've been presented with a plea of guilty form that was faxed to me. Looks like it came from Star. Well, I don't know who it came from, but anyway, you'll see Mr. Kirk's label on there too. But anyway, this is a form that has been prepared by the prosecutor's office and printed out. And on page 3, well, first of all, let me hold it up here to the camera for you to see. Can you see that form there, Mr. Kirk?
Yes, I do.
Mr. Smith?
Yes.
And you recognize it as the form that you looked at?
I do.
All right, and on page 3, there is a paragraph, and right below that, there's a sentence on the left-hand margin that says, I enter this plea voluntarily. Right below that is a signature that looks like Larry Smith. And I'll hold that up to the camera. Is that your signature there?
That is my signature, sir, yes.
All right. And do you recall when you signed this, Mr. Smith?
I signed it about 20 minutes ago.
Oh, okay. And then Mr. Kirk apparently got it back and signed it, and I see Ms. Collins had already signed it. So, were you able to speak with this with Mr. Kirk before you speak about this?
I spoke with him this morning.
All right. And do you feel that you've had enough time to fully consider this matter before making this decision?
I do.
You understand that when you sign this, it is an agreement to plead guilty, which means there's not going to be a trial. The next step in your case will be a sentencing.
Yes, sir.
Right? And are you entering into the agreement to plead guilty voluntarily?
I am, sir, yes.
You don't feel that you've been pressured or rushed into doing this at all?
No, sir.
All right. Now, the agreement states on page 1, and also at any time if you don't hear me or if the computer acts up on your end, just let me know.
Okay. Yeah,
We
you're
still
fine.
have a frozen screen for you, but I can hear you, so you know, I know that you are who you are, so that's not a problem. Okay, the agreement states on page 1, you're going to enter a guilty plea to both counts of the indictment, possession of cocaine and aggravated possession of methamphetamine. Both are violations of 2925.11 Ohio Revised Code. Both are 53 felonies. It also states that you understand that the maximum penalty for each of these offenses is 12 months in prison with a prison term imposed. The minimum is 6 months if one is imposed. There's also a fine available of up to $2,500 in each case, and there's a possibility of a driver's license suspension in each case of 6 months to 5 years. Do you understand that?
I do, sir, yes.
Okay, now, under the law, if you're convicted of both of these offenses, they could be ordered to be served consecutively, meaning one after the other. So that means that the possible maximum penalty would be 24 months, $5,000 fine. Do you understand that?
I do, sir.
And I know you're in Star from, is it Clinton County or Fayette?
From Clinton.
Clinton, okay. And so, if you should ever be sentenced to prison in both this case and in the Clinton County case, then those could be ordered to be served consecutively, being one after the other. You understand that?
I do.
And are you facing any felony charges in any other jurisdiction?
Yeah.
And where's that?
Clinton County, I'm waiting to be indicted for the same thing for possession.
Okay. So again, if you're convicted and sentenced in that case, that also could be ordered to be served consecutively. You understand that?
I do.
Okay. All right. Now, other than those two charges, are you on probation, community control, parole, or post-release control for a felony from any jurisdiction?
From Clinton County and Hyde County.
Okay. Yeah, you're on pretrial supervision here, I believe, what you're referring to in this case, right?
I'm on PRC from my prior number.
PRC, okay, all right. Well, again, if you are sentenced to prison, then, I don't know what is that 3 years of PRC or 5?
3.
Okay. Well, under the law, if you're sentenced to prison, in this case, the court then could, order you to, be sentenced, on your PRC case to 1 year or whatever time is left on your 3 years of post-release control, whichever is greater, and that would be served consecutively to the sentence in this case. You understand that?
I do, sir.
All right. Now, this case, post-release control is optional, and it is up to 3 years. And what that means is that, as you know, that if you are convicted, the adult parole authority will decide whether you should be put under PRC supervision under the terms they set by a parole officer for up to 3 years. And if that occurs, if you are found to have violated those conditions, they could return you to prison even though you served the entire term set by the court for an additional period of up to half of your prison term for one long violation. The maximum for any one violation would be 9 months, and the maximum for all violations would be half of whatever prison term is imposed. But again, if you commit a felony while under post-release control supervision in this case, then in addition to whatever sentence the judge in that new case would impose for that violation, that judge would also sentence you for committing that offense while under PRC in this case to a term of 1 year or whatever time left on 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively with the sentence in the new case. You understand that?
I do, sir.
And under the law, I'm not required to sentence you to prison. I can impose, in this case, community control instead of a prison term, which means you would be put under supervision of a probation officer of a term set by the court for a period of up to 5 years. And if during that period of time probation felt that you were not compliant, they would have to file a written notice of that with the court. There would be a hearing, and then if the outcome of the hearing was that you had violated, then at that time the court would revoke your community control and then sentence you to prison in these two cases to 12 months each or 24 months and fine you $5,000. You understand that?
I do, sir.
Right now, the count 1 of the indictment reads that on or about November 8, 2020 in this county, knowingly obtained, possessed, or used Schedule 2 controlled substance for cocaine. And then count 2 alleges the same conduct on the same day except is methamphetamine, also a Schedule 2. Both of those are a violation of 29, 25, 2011 of the Higher Revised Code and are 5th-degree felonies with the penalties I've described previously. Now, Mr. Smith, do you understand what it is you've been charged with in those 2 counts, what the state said you did, when, where, how they led that you did it?
I do, sir.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
I am.
Now, are you under the influence of any types of drugs or alcohol at this time?
I am not.
Are you taking any prescription drugs?
Elavil for my psych meds.
But other than that, nothing that interferes with your, well, does that interfere with your ability to understand the agreement that was you signed or anything that we've talked about here today?
It does not impair me in any way.
Okay.
I am of legal sound mind.
All right. Thank you. Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there are a couple of sentences that are printed in bold and underlined. I'll hold those up to the camera about halfway down the page, and you see where I'm pointing at there?
Yes.
All right, I'll read. There was another line below that that's been scratched out, so it doesn't apply. So here's what I understand applies, and it reads, defendant shall enter plead guilty to the indictment, state defense jointly recommend community control, and defendant be referred into drug court. Is that your understanding of the agreement?
It is, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, they did not, sir.
Under the law, Mr. Smith, the matter of sentence is up to the judge, not to the parties. So even though the state and you are recommending the same sentence of community control and admission in the drug court, that's not binding on the court. And so I will not make a decision until I hear all the information. And if I decide that's not appropriate, that you should be sentenced to prison, I can sentence you to prison for 24 months total, fine you $5,000, suspend your license, 26 months to 5 years. And I can also order you to serve PRC of either 1 year or whatever time left on 3 years of post-release control, whichever is greater, consecutive to the 24 months. You understand that?
I do, sir.
And regarding drug court, the referral simply means you're going to be evaluated and it'll be discussed with you, and then you'll make a decision whether you want to apply to that program or not. Under the law, I don't order people into drug court. They have to apply because it's a program that is much more intensive than regular community control, but it has the goal of, instead of just keeping you out of prison, addressing your addiction, your substance use disorder, any mental health issues you may have, and providing a broad range of treatment and services to you, to the end that if you are able to stay sober, you're not going to commit any crimes. Whereas with community control, you're just trying to stay out of prison while they do try to see that you get help. You know, that's not the primary goal. The primary goal is to keep you out of prison. You understand that?
I do, sir.
Okay. And there's also certain criteria you have to meet in order to be admitted into that. So I won't know what that is till the drug court coordinator evaluates you, and we have some other information gathered to determine if you're at first legally eligible, and then secondly whether or not I think you would be appropriate for the program, which is pretty much up to my discretion. You understand that?
I do, sir.
All right. Now, do you hold any kind of a license or certification from any state agency or commission for any type of a profession or occupation?
I do not.
All right. Now, you have certain constitutional rights, as I understand, before I can accept a plea from you in this case of guilty. First of all, you have a right to have an attorney. Mr. Burke appointed to represent you. Now, he wasn't simply appointed to work the case out, but provide whatever defense might be available to you under the law that you wish him to provide. So if you decide that you do not want to plead guilty, he will still represent you, defend you, and that will include having a trial if that's what you want. You understand that?
I do, sir.
Right now, in the Constitution, Mr. Smith, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury to be on your trial day. After those 12 were selected, the evidence would be presented, and the jury would be instructed on the law by the judge, and then that jury would decide by a unanimous verdict, meaning all 12 have to agree, as to whether or not you were found, or whether or not the state proved your guilt on either or both charges. And again, that's unanimous on both charges. Now, if you didn't want to have a jury trial, but you're not wanting to plead guilty, you can waive in writing, and waive in the legal sense means to give up your right to have a jury trial. And in that case, you have what's called a court or bench trial. That means that instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt, or proved the unreasonable doubt. You understand that?
I do, sir.
Right now, in the Constitution, Mr. Smith, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
I do, sir.
Right now, under the Constitution, you have a right to cross-examine cross-examine, see, I already said that, didn't I? That you have the right to cross-examine the state's witnesses in front of an open court, so they'd have to come into court and testify in front of you and your attorney and anyone else is present. And then after the prosecutor's done asking questions, then your attorney asks questions, which is called cross-examination. The purpose of that would be to try to help bring out evidence that helps your side of the case. You understand that?
I do, sir.
And under the Constitution, you have the right to use the power of this court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, a jury request, court issues a subpoena, that's court order. And that forces those witnesses to come to court to testify on your behalf, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court. Do you understand that?
I do.
Now, under the Constitution, Mr. Smith, you have the privilege against self-incrimination. And that means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can't. You decide. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way from any person at any time in the proceedings. And in fact, no one's allowed to even talk about it with one exception, and that is if there's a jury trial and you do not testify, the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. You understand that?
I do.
Now, under the Constitution, you have a presumption of innocence, which means that you cannot, or that you are presumed innocent until proven guilty by the state of Ohio on every essential element of each offense that is charged in the indictment. So the burden isn't on you to try to prove you're not guilty. The burden is on the state to prove you're guilty. In fact, you're not even required to present any evidence at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on each element of each offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
I do, sir.
Now, originally you entered a plea of not guilty to these two charges, Mr. Smith, that denied the allegation in the indictment, denied you committed any crimes, and it exercised or invoked all the rights I just described. If you change your plea today from not guilty to guilty on these two charges, that's the complete opposite of the not guilty plea. The guilty plea admits the allegations in each charge, admits that they're a crime, that you committed that crime, and that plea gives up all the rights that I've described for you this afternoon, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty would waive or give up the right to have a jury or court trial. Waive or give up the right to confront witnesses against you and cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. You would waive or give up your privilege against self-incrimination because you're the one saying you're guilty and that's what's used to find you guilty. You would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove that you're guilty of either offense. It also waives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I sent you the maximum sentence, or under other limited circumstances, you can file an appeal. After you file within 30 days of your sentencing entry, you can file. Do you understand all of that?
I do, sir, yes.
And are you a U.S. citizen?
I am.
Now, Mr. Smith, do you have any question about the either of the charges in the indictment or the possible penalties?
No, sir.
You understand this?
I do.
Have any question about the plea agreement?
I do not.
You understand it?
I do.
Again, you understand that the recommendation as a sentence as to whether or not you're admitted into drug court is up to the court, not to the party, so the recommendation is not binding.
I do.
You understand that?
I do, sir, yes.
Okay. Have any questions about the constitutional rights I've explained to you today?
Yes.
You understand those?
I do.
You have any questions about the plea of guilty, what it means, or what will happen if you enter that plea of guilty to these two charges today?
No, sir, I understand.
Okay. And you have any questions you'd like to speak with, or anything you'd like to speak with Mr. Kirk about before we go any further?
I do not.
You have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision, Mr. Smith, to withdraw your not guilty plea, plead guilty to these two charges in the indictment under the terms of this written plea agreement we've just gone over?
Yes, sir, it is.
Okay, then as to count one in the indictment that alleges that on or about November 8, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use, as Schedule 2 controlled substance, to wit cocaine, in violation of section 2925.11 Ohio Revised Code. Charged with possession of cocaine and 50-degree felony. Very possible penalty between 6 and 12 months imprisonment, a fine of $2,500, and possible license suspension of 6 months to 5 years. How do you plead?
I plead guilty.
And then count 2, which alleges in honor about November 8, 2020, in Huntington County, Ohio, knowingly obtained, possessed, or used Schedule 2 controlled substance with methamphetamine in violation of 2925.11 Ohio Revised Code. Charged with aggravated possession of methamphetamine, also a 50-degree felony with the same penalties as count 1. How do you plead?
I plead guilty.
All right, thank you. The court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Rule 11. The plea of guilty is accepted and ordered filed as to each count. Defendant is found guilty of those 2 counts as charged in the indictment. And again, the court finds that this was a knowing, intelligent, voluntary waiver of his rights under Rule 11. Court will order a pre-sentence investigation and will include assessment for substance abuse and mental health treatment, and cases referred to the drug court docket for evaluation. And you don't have any more court dates in Clinton County until you get a indictment, is that correct?
That's correct, sir.
Okay. We'll set this for sentencing on August 19th at 1 p.m. We can do that by Zoom. Oh, how long have you been at Star?
I'll be here till October.
Okay, so you just got there. All right. So we'll set that by Zoom as well, if that's okay with you. You can talk to your attorney about that, and we'll go from there. Make sure.
Your Honor,
Pardon?
Your Honor, I'm scheduled to be in Clinton County at 1:30 that afternoon.
All right. Then let's look at earlier than today then. How about 11 a.m.?
Yes, that would work.
All right, I'll make that 11 a.m. then. Okay.
Thank you, Your Honor.
And then we'll send a Zoom invitation out to Star and your attorney. Keep in touch with your attorney about what's going on in Clinton County. And our probation office will probably be in touch with you by Zoom as well to do the PSI interview, as well as the drug court coordinator do the evaluation and intake application. So we should have that done by middle of August. So, all right, anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, thank you.